Good afternoon and welcome. I'm Troy Duster, a sociologist here at UC Berkeley. And before we get started, I have an announcement to make. Upcoming event. Wednesday, November 4th, assistant professor in the School of Social Welfare here at UC Berkeley will give a talk entitled Tuskegee, Then and Now, an exploration of historical trauma and the life of a direct descendant. And the talk will be here from noon to 1:30 p.m. Next Wednesday. Always ask all to turn off their cell phones. Please do forgotten. This is being recorded. The procedure is, as usual, 45-minute presentation and then a Q&A period. So let me begin by trying to set the context for Torsten's talk. Now, 5 years ago, there was a front page story in the New York Times which caught the attention of many family researchers. Why? Well, it was a story of an immigrant from sub-Saharan Africa. I forget the name of the country. It could have been Senegal, could have been Ghana. It was a male widower. The wife had died a few years previously. And he had been clearly the family person who was raising these 4 or 5 children. Exact number I've forgotten, probably 4 or 5. He immigrated to the United States and had a green card. There was no question about his being the patriarch of the family. He clearly was the person who raised up these 4 or 5 kids. The problem was that he had left one of them back in sub-Saharan Africa, and he then went to get that person as his kid, as a 4th child, a visa. But when he went to get the visa, they demanded that there be a paternity test. There's been concern, of course, that if you bring people in just because you claim that they're your children, you may be skirting the law. So they instituted a DNA test for paternity. Now here's the double whammy that happened. Not only did they say that the paternity suit failed to show on the Y chromosome that this was, quote, the actual father. Imagine the trauma, therefore, for the father, who then had to discover that his deceased wife had been unfaithful. So you get into this remarkably complex zone of what to do and what is actually a legitimate family unit. It generated a lot of controversy in this country, in family studies. So many people, of course, sociologists, would play the claim that the unit of analysis really should be the family as it's being developed, not questions about its biological genetic inheritance. And today's talk is going to go directly to that issue. I don't know what happened in that case. Maybe you remember what it was, Torsten, but okay. Torsten Heinemann is professor of sociology at Universität of Hamburg, as you can see from the slide. His interest in research in the last few years have been on primarily science studies, particularly the neurosciences and genetics. And for that work, he was awarded the prestigious Marie Curie Fellowship, a 2-year grant which he chose to bring here to Berkeley and to work here at this institute. He was formerly Humboldt University professor in Berlin, and he worked as principal investigator at the Goethe University in Frankfurt. His most recent book is a co-edited volume entitled Suspect Families, DNA Analysis, Family Reunification, and Immigration Policies, published just earlier this year. So it's hot off the press. As I indicated, he's going to address the whole arena of immigration policies as they relate to this emerging phenomena in science studies across 21 countries. The use of DNA testing to authenticate whether or not someone is really a part of a family system. Torsten.
Thank you so much, Troy, for the introduction, and thank you very much for the opportunity to present here today and discuss with you about the use of DNA testing for family reunification. So Troy already started with one interesting case that already illustrates some of the issues at stake when it comes to the concept of family and family reunification, and then the use of biotechnological tools to assess family concepts in this context. And what I will do today is firstly give you a general idea and a background on what family reunification actually is, what it is about, and then also how DNA comes into play here and when it is used. I will then look at DNA testing for family reunification in a comparative perspective, and I will look particularly at 3 European countries, that is Austria, Finland, and Germany, and also compare this to the United States and the use of DNA testing here in the US. And then in the next part, I will outline some of the issues at stake here, particularly from a social science perspective, so that is mostly social-political issues. And conclude with some remarks on the very popular concept of biological citizenship that has been recently used quite often in science and technology studies to denote some new phenomena and emerging fields that we observe when it comes to the application of biotechnologies in society. And the talk today, and particularly the comparison in the 3 European countries, goes back to a research project that I've done with a couple of colleagues in Europe, and then the comparison to the US. This is still an ongoing project with my colleague Catherine Lee, who published this book some years ago. Fictive kinship, I can give it around so that you can have a look. And so we're currently trying to do this more systematic comparison between the EU and the US, so this is still ongoing. But with regards to the European perspective, we've done extensive empirical work. That is, we've interviewed more than 90 stakeholders, and we, I think, pretty much covered all the stakeholders involved. That is, we interviewed the applicants for family reunification, lawyers who are specializing in immigration law, and the geneticists who carry out the DNA tests, then self-help groups, NGOs, and other political actors in this field, and also representatives of immigration authorities. And so the argument of today's talk is based on this empirical analysis, but also on an extensive document analysis that we've done. Okay, so let me start with some, or with a general background on family reunification. Generally speaking, family reunification refers to the right of foreign family members living abroad to join their relatives who hold permanent residency or are citizens of a given country. And this idea of family reunification goes back to the protection of the family, as it is laid down in the Universal Declaration of Human Rights, where it is stated that the family is the natural and fundamental group unit of society. And in the European Union, for example, the protection of the family is regulated in the European Convention of Human Rights and also in the Charter of the Fundamental Rights of the European Union. And then on a national level, there are various regulations in place to protect the family. And then in relation to this, or based on this idea, we also have this idea of family reunification as a right in order to protect family members that were separated for various reasons. And so the right to family reunification is actually an integral part of many countries' immigration regimes. And it is actually in pretty much all Western industrialized countries the most important form of legal immigration. And for example, in the US, family reunification accounts for approximately 60 to 70% of all immigration. In the year 2012, it were about 64% family reunification cases. In the EU, it is approximately 50 to 60%, so slightly less. Well, it's quite obvious that if you apply for family reunification, you have to prove your family relation in one way or another. And mostly this is done by official documents, and in some countries also by interviews. However, what regularly happens is that immigration authorities question the authenticity of the documents provided, and also other evidence that is provided, or they suspect the fraudulent use of family reunification. For example, in the US there was an official statement by the Homeland Security that actually stated that they suspect that in 80% of all family reunification cases there's some sort of fraud involved. So only 20% of all cases are actually regular cases. And so since the early 1990s, many countries around the world have begun to use DNA testing for family reunification in order to resolve these problematic, or supposedly problematic cases, I should say. And today at least 22 countries around the world are using DNA testing for family reunification in decision making. It's actually growing. So when we started the project in 2010, we could only find 13 countries around the world that were officially using DNA testing. And since then, so in this very short period of only 5 years, at least 9 more countries have been added to this list, and it's probably even more. What's quite interesting, just as an additional information, the first use of DNA testing in practice was not a case of criminal investigation, but in fact it was a case of family reunification. So when Sir Alec Jeffreys invented the idea of the DNA fingerprint, as he called it, it was then first applied in the field in a case of family reunification in the UK. And this is the original article published in Nature in 1985. And so this is the actual first case where DNA testing was used in practice. I can tell you a bit more about the background if you like later, but I will leave it at that for now. It's just to highlight the importance of DNA testing in family reunification, because when we speak about DNA analysis these days, we mostly think about criminal cases, but in fact family reunification is a very important field of application in this context. Okay, so now let's look at the legal framework for family reunification, and particularly in the EU. What is interesting about comparing European countries is that actually when it comes to immigration, for example, and you all know that currently there are challenging developments in the EU when it comes to immigration, particularly with the refugees from Syria. And then subsequently there will be also a lot of applications for family reunification. And what is interesting about this is that actually there is a common framework within the EU with regards to immigration and also when it comes to family reunification. And this common framework was introduced in 2003. And the code you see here is part of this Council directive. And Article 5.2 is important because here it is stated how you actually prove your family relation, because this is what the use of DNA testing is about. And what's quite interesting is that actually you don't find any mentioning of DNA testing in this whole Council directive. And mind you, that was in 2003. The first application was in 1985. And then already, as I said, in the early 1990s, many countries around the world used DNA testing to resolve these cases. And so 13 years later, still no mentioning of DNA in this context. And so actually, all biological assessments only come into, or all go under additional investigations, or here this said, conduct other investigations that are found to be necessary. And then DNA testing is one of those. And other than that, it's only interviews and documents that are explicitly mentioned. And then the first time that actually DNA testing was explicitly mentioned on an EU level in an official document was in 2011, when there was a green paper published by the EU to assess the implementation of this Council directive. And so there were several questions, and then in one of these questions there was a reference to DNA testing. But it's also quite telling how this is linked here, because this question explicitly links DNA testing to the fraudulent use of family reunification. So it reads, do you have clear evidence of problems of fraud? And then, do you think rules of interviews and investigations, including DNA testing, can be instrumental to solve them? So this is the first time that DNA testing is mentioned on an EU level. And I'm emphasizing this because DNA testing was actually implemented and is still mostly in most countries used as an option. It is basically presented as a voluntary additional type of evidence that immigrants can resort to if they, for example, simply don't have the required documents. And so it's strictly voluntary in most countries. And then it is quite telling that here it is explicitly linked to fraud and not framed as a voluntary type of evidence. So what I will do now in the next couple of slides is do a little comparison between the countries. And so basically the slides are all the same. So what you see is on the left is the countries, and then you have different types that are interesting in the context of family reunification. And then again, for reading this, actually what is quite interesting again is that these three countries are actually regulate or should actually have quite similar, for example, definitions of the family, and the type of evidence should be kind of similar because we have this EU regulation. But it turns out that there are significant differences in these countries, which also makes this comparison so interesting. So, as Troy already mentioned, one aspect that's key in the question of the use of DNA testing for family reunification is the definition of the family. Not only when it comes to the use of biotechnological assessments, but in general, how do you define family in family reunification cases? And so when you look at these slides, you will see that Austria and Germany have a very strict understanding of the family. Basically, it's a nuclear idea of the family that only comprises spouses, so married partners, and their underage children. Nothing else counts as family. The moment a young adult reaches the age of adulthood, which, for example, in some German federal lands is at 16, then this still child doesn't count as a family member anymore when it comes to family reunification. Also, parents of applicants that are over the age of 18 or 16 don't count as family. And so this is a very narrow understanding of the family. And then in contrast to this, Finland has probably the most extensive definition of family that also includes extended family members, that is siblings, aunts and uncles. So it's a very broad understanding of family, and you can sponsor a lot of different persons to get a visa to enter the country. And interestingly, actually the US have a fairly broad understanding of family that includes, it's quite complicated because there are differences for permanent residents and US citizens, but in general it is a very broad understanding of the family that so you can sponsor your parents. So if you're over 21 in the US, you're allowed to sponsor your parents to come to the country. You can sponsor siblings if you're over the age of 21. And also you can sponsor children of any age, which is not possible in the other countries except Finland. So then when it comes to proving a family relation, it's also quite interesting what types of investigations will be used or conducted. And so in Germany, it is the whole process is based on documents. So you pretty much don't have to see an immigration officer at all. You can just mail everything to the immigration authorities, and the whole process will be done remotely, apart from the DNA test that may come into play. But generally speaking, it's all done via documents. And in the US, it's actually quite similar. So at least officially, it should in most cases be only based on documents, and only under very rare circumstances there will be interviews conducted. And then in Finland and Austria it is more diverse. So in Finland it's actually the other way around than in Germany. So the emphasis is on interviews, and then documents will only be used as an additional type of evidence. And in Austria also interviews will be conducted, but the emphasis is on the document, and then the interviews just complement the rest. And then obviously based on these types of evidence that you provide, you can also test different kinds of families. So basically, if you only submit documents, you can prove a documented family relation, for example, a marriage, or then subsequent children as part of this married couple. And so this is the case in Germany and the US. And then in Austria, because they also include interviews, they ask about an existing family life. The interview is still on the document. This is why it reads documented family life. But still there's also an aspect of living together. And for example, you have to prove that you have shared a household for a certain period of time, which is not the case in Germany. And then in Finland, as I said, the emphasis is on the interviews, and this is why they actually check for an existing social familiar relationship. So it's not just that the official marriage counts, but it is really that they want to see an existing family life. And as you can imagine, for refugees who may be separated for years, this can be really challenging to prove that they have such an existing family life. But I will come to this again later. Going on then, how was DNA analysis introduced in this context? As I said, in the UK, or the UK were the first country to use DNA testing for family reunification, and then Finland and Germany were early adopters. I still haven't figured out when exactly in the US the first use of DNA testing for family reunification took place. So I still have to verify this, but it was in the early 1990s. And then Austria was rather late with adopting this policy, only started in the 2000s. Apart from Germany, or except from Germany, all countries also did pilot projects, but all did this pilot project after they already introduced this measure, which is also quite interesting. For example, in the US, this pilot project in 2008 actually was conducted to introduce mandatory DNA tests, particularly for applicants that apply as refugees, or who are accepted refugees in the US, subsequently are permanent residents, and then apply for family reunification. And there, for particular countries, they tried to introduce a mandatory DNA test. And so there was this pilot study 2008 where in total they tested 3,500 applicants. And this is also where this number with this 20% regular cases and 80% fraudulent cases comes from this pilot project. Then certainly it is quite interesting also to see when on a formal level DNA testing was codified in some legal context. And actually, particularly it is telling when you look at the case of Germany. So as I said, it was first used in 1991. And only in 2010 there was an official regulation of the use of DNA testing for family reunification. So basically, DNA testing for family reunification was conducted in a gray area for almost 2 decades. And then it's also interesting that it was not regulated in immigration law, but as part of the Genetic Diagnostics Act, which is mostly for native citizens to protect the use of genetic information when it comes to genetic discrimination, for example, insurance and so on. And then there is one section that deals with DNA testing in immigration cases, and that is another problem that raises additional issues. In Austria and Finland, it is actually part of the alliance acts in these two countries. And Finland was quite transparent when it came to the introduction of DNA testing for family reunification. So already in 1991 they first mentioned it in the law, and then they have now this law from, that dates back to 2000, where it is quite meticulously regulated on what the DNA test costs, how the practice will be, and so on. But this is actually one of the very few countries that was that transparent. Then the administrative procedure is also very important in this respect, because it also relates to the question who has the power to question these documents, and then also who has the power to request, or rather the official language is to offer the DNA test to the applicant. So officially you don't request it as an immigration officer, but you just offer it as an alternative. In Austria, that is also from a methodological perspective quite interesting and a challenge for us. There is actually no real family reunification procedure. Basically, they have just an additional asylum or procedure for refugees, and it's an expedited procedure, but it's not really family reunification. So the moment the family relations are verified, doesn't mean that these people get a visa to enter the country or get permanent residencies, but instead they are allowed into the country to then undergo the same asylum procedure the sponsor had to undergo first, which is weird, and also was for this comparison quite a challenge to include this. And then in Finland, it's actually a very centralized procedure, similar also to the USA, where you have pretty much one authority that runs the overall procedure, including interviews, and then this is the place where the decision will be made. And in Germany, you have a very decentralized approach. So it is each and every embassy in the country where you apply for family reunification or where the applicants come from, they will handle the whole procedure, and they have quite a scope of interpretation when it comes to applying immigration law in this context. And so once you order the DNA test, there's also this question how this document is actually used. And here you can see remarkable parallels between Germany and the US. Pretty much the DNA test is kind of a trump card. So you submit your documentary evidence, like certificates of birth, certificates of marriage, to prove the family relation, and if those documents are deemed insufficient or the immigration officers suspect fraud, then you are allowed to submit the DNA or the DNA test results, and those are kind of the trump card, and they pretty much trump every other document you provide. And it's more complicated in the case of Finland and also Austria. In Finland, it's actually just one piece of evidence that's used. And we have documented cases where, for example, there was a biological relation, but the immigration officers found the existing family life to be non-existent, simply because this family lived apart for so long. And so the application was actually declined, even though there was an existing biological relation. And in Austria, it's kind of, you could say, the DNA test becomes kind of a truth machine or a lie detector. So it's this idea of you provide documents, and if you then also, or if those are deemed to be inappropriate or false, and you then subsequently hand in the DNA test result, then automatically credibility from the DNA test is kind of extended to all the documents and also to the interviews. And suddenly the applicant is more credible, simply because the test was telling the truth. It is assumed that also everything that has been said in the interviews must have been true.
A quick question.
Yeah, sure.
Do you plan to get to the difference between the Y chromosome and mitochondrial in your noise?
Yes.
You do, okay.
Or at least briefly, and then maybe in the discussion we can discuss this more extensively. it's also interesting to see how how the DNA test is then, or what the function of the DNA test is, and this is quite different in the different countries. And then also the subjects differ quite significantly, both in the US and in Germany. Native citizens and permanent residents may be subject to DNA tests for family reunification, while in Austria and Finland this is pretty much only related to refugees and so to accepted asylum seekers who then apply for family reunification. There were no documented cases where permanent residents or then native citizens had to undergo DNA testing when they applied for family reunification. And then here you see the difference in the duration is quite remarkable as well. And in the US and also in Germany it can be actually years, because in the US it also depends on the quota, because you have this very complex quota system, and depending on in which quota your family member falls in, it may take actually years till you're allowed, even though your family relation is already verified, you have to wait until there is space within this certain quota. So ideally it could be less than 6 months, and there are cases where it went so fast, but it can take significantly longer. So I can be more brief on this. So these are some practical aspects. So in the US you have 40 laboratories who are accredited by the American Association of Blood Banks, and only those laboratories are allowed to conduct DNA tests for family reunification, or there are more that are allowed to conduct it, but these are the only laboratories where the tests are then accepted by the immigration authorities. And the tests, the cost for the test vary because it's a market, and so it's about $450 for a family of 3, plus an additional $150 per additional family member. It's quite interesting that the article you mentioned, Troy, that dates back to 2007 or 8, already said that it was $450 for a family of 3, which is actually, or by that time was incredibly competitive, because when we look at the European countries, prices were significantly higher. When we started the project, we still found several laboratories that charged more than $1,500 US for a family of 3. And then since then, the prices have dropped significantly. Only Austria has still very high prices, and then obviously this can be a challenge for the applicants. And here you already see in Finland, in some cases, mtDNA tests will be conducted, and this costs more. One important aspect, and also a point of debate, is the question who has to pay for the DNA test. And in both the US and Germany, it's actually quite clear, because the burden of proof is always on the applicants. They have to pay for the tests. While in Austria and Finland, there is this idea that you have to guarantee a fair procedure for the applicants. And then if the immigration authorities deem it necessary to get additional evidence for the family reunification, it is up to them to pay for the test. The only difference is that in Austria you have to pay as an applicant upfront and will be reimbursed afterwards, while in Finland the test will be paid for by the Central Immigration Authority, we agree. And then in both ways there is this idea that you can actually get this money back, or ask the money to be reimbursed if the applicant made fraud claims and if the test turns out to be negative. So now to the procedure of DNA analysis. In most cases, you have the sponsor for family reunification, or the petitioner, as it is called or he or she is called in the US. And so this person is already in the country, and then samples will be taken certainly in this country. but then for all the other family members, the samples will be taken in the embassies in the respective host countries. And so the test kit will be shipped from the laboratory to the embassies, and their authorized personnel will conduct the test. And it's quite interesting that actually the same test kits are often used as in forensic cases, which is important with regards to the use of these DNA test results in later proceedings. They could, for example, be stored in DNA databases that are then searchable also by law enforcement, by the police, and so on. And then in standard cases, you will at least test 12 STR loci. So STR stands for short tandem repeats, and these are within the non-coding parts of the DNA. You have certain regions, microsatellites, that have repeating parts of base pairs, and so you can just pretty much count how often those parts repeat. And then these are highly coding, and so you give them on to the next generation, inherit them from your parents, and so on. And this particularly also holds true for empty mitochondrial DNA testing from the maternal side. But normally empty DNA testing is not used in most cases. It's actually only Finland where it is systematically done, which raises additional questions. But then generally you have 16 of these microsatellites that you test. I will then show you the test results so that you get an idea what it looks like. And then this idea is that you should have a reliability of 99.99% in Europe, 99.5% in the US. And this means that it's not that 1 in 1,000 or 10,000 in the case of Europe test goes wrong, or 5 in 1,000 tests are simply wrong. It's or this is not the meaning of this percentage. It's rather that you assume the person can be, by 50% chance, be the alleged mother, father, daughter, and so on, or 50% can be excluded. And then, because you don't actually look at the whole DNA sequence, but only these 12 or 16 regions, there is a certain likelihood that you find among the whole population on Earth another person who just by chance has the very same STRs or repeats on this very position. And so there is a theoretical chance that you find someone who is not related but with the same, at these 12 positions, the very same repeats. But then again, you have, for example, this result of 99.99%, which simply means that 1 in 10,000 persons, or you may find another person in 10,000 who has the very same repeats in these 12 or 16 positions. But if you look at test results, you will normally have likelihoods that are much more higher than people living on Earth. So at least from the scientific side, scientists and geneticists claim that these tests are bulletproof. They are not, but we won't go into these details now. Here is just an example of a positive DNA test result, and it kind of shows from the perspective of the immigration officers the beauty of this test. Because just imagine, you get these certificates of birth and marriage, and they may look different because they were issued in a different period of time, and they change over time. And so it's really challenging to assess those. And then you get a notarized letter from an accredited laboratory. And you have this table, and here, for example, you have 4 kids, the alleged mother and the alleged father. And then you have the STR systems that I mentioned over here. And then basically it's quite simple. You have these repeats, and you have to inherit it, one of the repeats from the mother and from the father if you test this family. And so, for example, if you look at the first child, the first system, D3S1, and so on, you have 15 and 16 repeats at this very specific region, and so you have to find the 15 and 16 with the mother and the father. And as you see, it's 16 from the mother and 15 from the father. And so you can just go through the whole table and you will see that it all matches all the time. So, for example, the last row, ACTVP2, it's another microsatellite system that is regularly tested. And then the first child has 18 on 28.2. And so, again, you need to find the two repeat numbers with the mother and the father. And you do, the mother has 18, and so the first child inherited the 18 repeats from the mother. And then you have to find the 28.2. With the father, and in fact you do 28.2. And so what you get from the perspective of the immigration officers is something that seems to be just obvious and easy to read. And so the whole messy idea of family is translated into seemingly a very simple chart that can be read like this. And then it gets even better. You get the respective tests. So this is a test that has been done in a German family reunification case. And so the first sentence reads that based on the DNA test that has been done, the mother or the woman AA is most certainly the mother of the children. By no means she can be excluded, and then the same is stated for the father. And then you see the likelihoods again, so it seems to be very likely that these 6 persons are related. And then the last sentence reads that based on the DNA test result, there is, or it's almost certain that there is a biological relation between all the persons mentioned in the test. And then just to show you, this is an exclusion here, where the dotted lines or the underlines, you see this is always an exclusion. So you have in the left column the child, then the alleged mother and the alleged father, and it's a full exclusion for the 3 persons. And for example, if you go to this system, the child has 6 and 8, and so you would expect to find the 6 or the 8 with the mother and the father, but actually you find no difference. So you don't find any match here. There are some matches in other regions, but this is what the exclusion looks like. So the advantages of the DNA test, as I already mentioned from the perspective of the immigration officers, it has its beauty because it suggests simplicity and it's easy to read and understand. And also it seems to be incredibly precise and powerful because you can also actually check for extended family members, siblings, uncles, and so on. It's also relatively simple to conduct the test because you just need a saliva sample, and this can be done quite easily, and then also the whole procedure is actually pretty fast. Once the samples are in the lab, the analysis can be done in less than 48 hours. And then it's fairly reasonable when it comes to the cost, particularly if you think of a procedure without the DNA test. Usually what will happen is that then accredited lawyers will be hired in the countries of origin, and they will conduct additional investigations, for example, interviews neighbors, so they will travel to sometimes rural areas to conduct these investigations, and this can be done extremely expensive, and so in comparison it seems that the DNA test is fairly cheap. But certainly you can imagine it also raises a number of issues, and this is what I would like to point your attention now. So one of the first issues is the question of voluntariness. As I mentioned, in most of the countries, and particularly the 4 we looked at in this presentation, the DNA test is presented as a voluntary option. It's just offered to the applicants, and it's always claimed that it is a last resort if no other documents were found to be useful or were found to be adequate to prove the family reunification or family relation, I should say. So the problem actually is that if you look how it is used in practice, it is almost an obligation to conduct the test, because if all other documents are rejected and you still want to proceed with your family reunification case, you almost have no other opportunity than to undergo the DNA testing, which also means that an informed consent is pretty much not a useful idea, because it's almost impossible to give informed consent in such a situation of distress, excuse me. And then also, this is quite similar in the US and also in Germany. For example, in Germany there exists a list of 40 blacklisted countries where documents are not accepted at all. So it's mostly countries from sub-Saharan Africa. And when we started the project in 2010, this list had only, or comprised only 34, 35 countries, and it's continuously growing since then. And so now we are way above 40 countries that are blacklisted. And for applicants from those countries, there's pretty much no other opportunity than resorting to the DNA test in order to be reunited, which is a huge issue, as you can imagine. Then the second aspect that is important is certainly the question of the understanding of the family. So when we look at the understanding of family in most Western countries, we observe a pluralization of family concepts, same-sex partnerships, and also with the use of reproductive technologies, we have different patterns of family life these days. And then in this way, the German Federal Constitutional Court, for example, stated in the press release, quote, that biological parenthood is not prioritized over legal and social notions of family in the jurisdiction of the Federal Constitutional Court. And the Finnish Immigration Service legally goes even so far to say that, quote, a purely biological relationship is not, however, sufficient for a positive decision on a residence permit without a background of a genuine permanent family life. So here the emphasis is clearly on social understandings of family. But what we observe with the introduction of DNA testing for family reunification is a generalization of family and the understanding of family. So the concept of family is narrowed down to a biological and supposedly natural idea of the family. And this certainly devalues other ideas of family concepts. And to illustrate what it actually means, just one case that is quite telling. So there was a case of family reunification in Germany in 2010, where 3 persons who all were already in Germany, but only one was officially a permanent resident, all from sub-Saharan Africa, no, actually from Somalia. They applied for family reunification, and so they submitted the documents provided. Certificates of birth, certificate of marriage, but those documents were rejected because they were deemed to be not correct. And then they were asked to undergo the DNA test. By that time, it still cost them 1,200 euros to take the test. And so the 3, it was a man, a woman, and a 2-year-old child. They went to the laboratory, took the test, and the test result was quite surprising. It showed that neither the alleged mother nor the alleged father were biologically related to the 2-year-old. So there was an exclusion of the family. What is quite interesting now is that the employees in the laboratory were so convinced that the 3 persons who showed up in the laboratory were in fact the family, the way they interacted, that they felt obliged to write a letter to the immigration authorities and to argue that this result can only be explained by an exchange of the children in the hospital. So it's quite remarkable because the institution that by its own definition excluded the idea of family or the existence of family still argued in favor for these 3 persons to be a family, and so clearly a social family, which is quite interesting. At the same time, we have to be cautious not only to look at the narrow understanding of family, because family reunification can also open up the idea of family when it comes, for example, to polygamous family relations. which is also quite interesting. And then a last issue that I want to mention is the potential aspect or the potential risk of genetic surveillance. One problem is that it is in most of the countries not strictly regulated what happens to the test results once the persons have taken the test. For example, in Germany it's quite the opposite. It's explicitly mentioned that if there is reasonable suspicion for that someone has committed a crime, that the DNA test results can be used in criminal prosecution cases. And so the DNA test result that is actually produced in an immigration case may end up in a database or in a criminal DNA database, which is a serious issue. And so the guarantees, the legal guarantees that citizens have in this country are not the same as, or applicants for family reunification do not have the same rights in this context. So now to conclude, I just want to briefly mention the idea of biological citizenship. If you look at the way DNA testing for family reunification has been introduced, it is clearly at least officially, or this is the official reading, that it is an empowering aspect of the applicants. So it is offered to them as an additional proof to make their claim. And the idea of biological citizenship, as introduced by Kushina in 2002 and then subsequently more systematically outlined by Rose and Novas, was that with new biological knowledge, it is possible to have new forms of collective actions, particularly in the field of medicine, so that patient groups can organize across borders by their shared biological traits and then make new citizenship claims, particularly when it comes to social health, to healthcare access, and to social participation. And so far in the debate, the focus has mostly been on the extension of rights, which is certainly important. And then also it has been many times noted that there is a decreased importance of the nation state, because now it is possible to organize on a supranational level based on these shared biological traits, and also that there is a radical break when it comes to eugenics and a racial or racialized past that we observed within the nation states. But when you now look at the way DNA testing for family reunification is implemented, you see that there is actually a neglected side in this whole debate that refers to the question of what biological prerequisites an individual must fulfill in order to become or be seen as a citizen. And so what we actually see is a continuation when it comes to this relation between biology and citizenship, and particularly on the level of the nation state. It is still the nation state that grants a right to family reunification, and so this reference to biology doesn't actually help here, so you can't make any claims on a supranational level. And also there is still this dimension of racial categories that play an important role. When you think of these 40 blacklisted countries, for example, in Germany, and also these pilot project that was conducted in the US that was particularly targeted at certain regions in the world. And then when you look at the explanation, you still find extremely racial explanations for these blacklists and also for these pilot projects. And so I think it is important, and this is what this project shows, that we need a more complex understanding of biological citizenship and a more rich, maybe, concept here, and that it's not just all new and an extension of rights, but there are also possibly dark sides of biological citizenship that have to be systematically taken into account. Thank you very much.